right of written application if they still insist on the recusal. Earlier, the prosecution counsel led by Adeboyiga Awomolo said they were ready for the commencement of trial as his witnesses were ready.
The prosecution and this court doesn't know the law. That is the fact.
Yes.
Poor knowledge of the law is killing Nigeria. Poor knowledge of the law, they don't know the law. This is a federal gazetted law of Nigeria that says here that the chief judge of Nigeria cannot tell Binta Nyako what to do. It's here. It's your law. Just obey it. That is why I do what I do. I agitate for Biafra. I agitate for Biafra. My right to agitate. My right. They turned it from treasonable felony now to terrorism. Stop talking when I'm talking. Binta Nyako said today, for the simple reason that she has no jurisdiction to try me. None whatsoever. I came out of courtesy and respect. She stands recused from my case and cannot try my case. There are things that are happening in this country that a lot of you do not know. It is my duty to make that very, very clear to all of you today. Because the lies are too much. The lies are too much. I sent a petition to NJC. I don't want to talk about it. Justice Binta Nyako is using her position for personal gain. For personal gain. Her son and her husband are facing corruption charges. And they told them that if they convict me, this is what happens. You can see it. They don't want the truth to come out. Nobody wants the truth to come out. Nobody wants the truth to come out. Nobody wants the truth to come out in Nigeria. That's the problem. Corruption charges. They sent her to my case so they can release or smoothen the pathway for the husband and the son. They are facing. It doesn't matter if they're off it. In a corrupt society, that's what happens. They are very, very corrupt. That is a breach of judicial oath. They have violated the judicial oath. They have shown bias according to Supreme Court. They are biased against me. Supreme Court said so. And that is why what is happening in the judgments and rulings concerning me has been happening. So, disobedience to Superior Court orders. Supreme Court said you are biased. You are against this man. You should not have revoked his bail. Nigeria went to Kenya and kidnapped him. These things are in the public domain. Why, therefore, are they insisting on trying me? A court order was entered. In that very court order, it was said very clearly and succinctly that she is no more. No. That she is no more going to try me. Why are they insisting? Why are they insisting? I ask you. Because they have no case against me. They have no case against me.
What happened this morning is uncalled for.
Go ahead.
Actually, what happened this morning is actually uncalled for. You can see how the defendant, Nnamdi, decided to represent himself. He asked the lawyers with the legal team that we should stop, that he wants to speak. Because Nnamdi is feeling that Nigeria is not fair to him. He's just a human rights activist agitating for self-determination with reasons. And one expected the federal government to address all those reasons that gave rise to this agitation. Of course, we also discovered that some other persons that are having this similar issue with Nnamdi. I'm talking about the offense of terrorism, Showore from the West, the president of Yeti Allah Kato from the North, Sondibu. Their own has been settled. Why is Nnamdi still in the detention? And the people are saying that it's because he's an Igbo. Buhari did it because the president, Tinubu, has come from the West. And this is not good for this country in any way. So we feel that there is still a room for them to withdraw these charges and so that we have peace. Of course, you now discover that the Court of Appeal, non-Court of Appeal is sitting in the whole of Southeast. The judges, the federal judges in the Southeast, judges of National Industrial Court, Federal High Court, Court of Appeal, they are not sitting because of the threats given by some persons saying that there is no justice in this country. So you can see how what Nnamdi is saying. I tried, though as a lawyer, is uncalled for, but I try to see his feelings.
Now, we saw your client use so many unprintable names.
Yes, of course, which I did not consent to. Of course, because what we are, as a lawyer, we have our rules of ethics. And you discover that when we are trying to calm him down, he said that we should sit down and walk away, that we should not represent him again. So he decided. So he's not a lawyer. So, and I think the judge and the federal government understand. Because many people have applied to the federal government. They are offended. Many other persons have applied, has begged the federal government, please use political means to resolve this particular matter. Releasing Nnamdi so that we have a peace. So, and then now the judge, on the issue of the judge recusing herself, there is a subsisting court order. That's what Nnamdi said. And what one expected the judge to first of all set aside that order. I don't say you give the order, you have the right to set aside the order. And even that to set aside the order, you to have now give way for you to have the decision into the matter. Thank you and God bless you.
So does it mean now you no longer represent?
Except he called us and asked us to continue. From what is in the court now, he has, maybe because of today's proceedings, are you going to say, because I have a letter he gave me, and that letter has not been withdrawn. So if he wrote to me and asked me, I will withdraw. It's my pleasure.
Your name
Maxwell Opera is my name. A member of the
you react to today's proceedings? We've seen that the case could not even go on as planned, and now she has adjourned the case sine die. What's the way forward?
Well, there's no way this case could have gone on anywhere, because in the first place, the court had lost jurisdiction to sit over this case since September last year. So we came here today on a limited appearance. We appeared under protest out of utmost respect for the judge and for the court, to listen to the court as to the reasons why we were invited before the same court that was recused in September last year. Nigerian public needs to understand the nature of a recusal. A recusal comes as a court order, and even non-lawyers are aware that once an order of court is made, the only way you can set it aside is to take it on appeal. Nobody appealed this order. The order is extant and subsisting, is still valid, and we were invited today to be informed about some memo from the Chief Judge that we don't even have a copy of the memo. So our submission on the record is that the court stands recused until that order is set aside.
No, sir, the judge, Justice Peter Yago, has adjourned this case sine die. What is the implication for your client?
Well, sine die is a word of art for indefinite adjournment. So she had no business, the court, like I said before, even having the case before her today. So adjourning it, sine die or not, really, it doesn't apply. But remember that we had requested this adjournment sine die last year, but it wasn't granted.
So
but now,
next?
Well, it's up to the judiciary and the federal government. We are not the prosecutor, we are the defense. You throw the ball to us and we catch the ball. We cannot reinstitute the case. Let them do the right thing. Our client recused the judge, and the judge consented to the recusal through a court order. So we await the day that this case will be recalendared before a new judge to try it. We're not afraid of trial, but we're afraid of injustice.
And aren't you scared that it might come back to her again? What if it's brought back to her?
Well, under the Constitution, it shall be resisted. It will be unconstitutional to have the same judge who stands recused to recalendar the same case and try it.
Thank you very much.
Thank you.